switch it off this board. Board. This one?
Yeah.
I need unlimited one. Unlimited one.
There is no.
Only just 5 pieces. Right. Okay. Yeah. Shall we start? Hello aspirants, welcome to Grace IS. So we have come up with an important topic of polity, that is alternative dispute resolution. UPSC for quite some time, it has been asking very regularly, particularly in mains, regarding alternative dispute resolution. Alternative dispute resolution. So that's why we thought that, we'll discuss this topic, and we'll also discuss one prelims and mains questions. So this is what we are going to discuss under alternative dispute resolution. What is ADR? ADR. What is ADR? What are the various types of ADR? Then we'll look into the, through which the ADRs are being implemented. What are the mechanism, ADR mechanism? And then we'll look into the prelims and mains questions of UPSC previous year. So let's start with the ADR. What is ADR? So if you have doubt, please put it in the chat box. We'll resolve those doubts. Okay. So ADR is a non-adversarial. It's a non-adversarial way of dispensing justice. Way of dispensing justice. It's a non-adversarial way of dispensing justice. And here, both the parties, they try to resolve the disputes in a cooperative manner. So what is the main thing here is that it's a non-adversarial. What do you mean by non-adversarial? Basically, in a regular case, in a regular disputes, there is win-lose situation, isn't it? There is a win-lose kind of situation. Either party, either the party win or lose. Here, we are going beyond the win-lose case, and here basically it's all about that the dispute is resolved in a cooperative manner with the consent of both the parties. Right? That's the reason it is called non-adversarial way of dispensing justice or resolving the disputes. Now, what is the need for ADR? What is the need for ADR? What is the need? Need for ADR. Why ADR is required? So you all must be knowing that, there are a lot of tendency of cases in the regular court. It's almost 51 million cases are pending at the various level of court. from Supreme Court to the lower judiciary, 51 million cases. Alone in Supreme Court, more than 80,000 cases are pending. Alone in Supreme Court, more than 80,000 cases are pending. And some of the cases has been pending for 30 years. So you can imagine the kind of the judicial burden or the kind of delay the cases takes to get resolved. So to deal with these issues of deburdening the courts, deburdening the regular courts, the alternative dispute resolution has come into being. So what was the need? Basically the need was because of too much of pendency of cases, there was too much burden on the regular court, and also it has resulted in so much of delay to resolve the disputes. The reason also being the regular court follows very detailed provisions, like they follow for every small things, you know, they provide a very detailed provisions, like for evidence and all. Indian Evidence Act, the procedure of Indian Evidence Act has to be followed. So that also the code procedure also results in, you know, the complexity and delay in resolving the cases. So one is that there is too much of burden on the regular court. The ADR will result in deburdening. Secondly, because of too much of following of the procedure, the resolution of the disputes takes so much of time, it results in so much of delay. Through ADR, you can resolve the dispute in a more speedier manner, in a more efficient manner, Further, because of so much of delay in the cases, and also, you know, you have to pay the court fees and the lawyer's fees has to be paid, and because of the delay, the cost become very escalating in nature. So that also one of the reason is that because it's speedier resolutions, and also it is inexpensive because it can be done in a much more faster manner. The delay will not be so much, and also the court fees are being waived off. The court fees are being waived off. So because of these reasons, that it results in deburdening of the regular court, it provides cheap, inexpensive and speedier justice, and because the court fees and other necessary expenses are being waived off, so it is much more cheaper, it is much more speedier, because the procedures, rules and procedure are not followed in that manner as it is followed in regular court. Of course, it doesn't mean that natural justice is not followed. Doesn't mean that, you know, the quality of justice provided by these mechanism through the ADR, it is in any way compromising on the quality of justice. It does not compromise on the quality of the justice, because the natural justice principle has to be adhered even by these ADR mechanism. What is natural justice? I hope all of you know what is natural justice. So natural justice is nobody should be, there are three, basically points to be remembered here. Number one, that nobody should be punished unheard. Nobody should be punished unheard. Nobody. nobody should be punished unheard. Means before the punishment is given, fair chance of defending has to be provided. So the trial has to be, nobody should be punished unheard. Nobody should be judged in its own case. Nobody should be judged in its own case. So you can take up your pencil and paper, your notebook, and you can note down all these points for your revisions. So yes, what we have seen, that nobody should be punished unheard, nobody should be judged in its own case, and an authority should act. Authority should act in a bona fide manner. Bona fide manner means impartial manner, in a neutral manner. That is what an authority or a judge is supposed to behave, in a neutral and impartial manner. So these are the basic principles of natural justice. So even in the ADR, alternative dispute resolution mechanism, the principle of natural justice must be followed. Very much it is followed. So that's why in no way it compromises the quality of justice. So coming back to this. Yes, so we have seen the need for ADR. Now let's look into what are the way the ADR work, or what are the types of ADR. Types of ADR. So in this, there can be ADR can be through arbitration. It can be through arbitration. It can be through arbitration. It can be through conciliation. It can be through mediation. It can be through negotiation. So the ADR, alternative dispute resolution, can be taken place through any of this way, through arbitration, through conciliation, through mediation, through negotiation. So let's see each of these terms. What is arbitration? So arbitration, here the dispute is submitted to an arbitrator tribunal. Arbitration tribunal. The dispute is being submitted to arbitration tribunal, right? An award is being given, and mostly it is binding on the party. An award will be given, and mostly I'm talking about that mostly it will be binding, though people can take the appeal, but then mostly it will be binding in nature, and it is a formal way to resolve. Arbitration tribunal. Conciliation. What is conciliation? Yes, here the matter will be taken to an arbitration tribunal, and mostly the award will be binding on the parties, though appeal can be taken against its award. Conciliation. Here an impartial third party will be involved. Impartial third party. So it is more informal in nature. Impartial third party will be involved to resolve the disputes, right? And it can be non-binding. Binding, it will happen only when people accept it. So it depends upon the party to accept the award or not to accept the award, right? So it is a more informal way, and here impartial third party will be involved in conciliating the disputes. I hope you got the clarity between arbitration and conciliation. Arbitration, where it will go to an arbitration tribunal. It's a more formal way of resolving disputes in comparison to the conciliation. In conciliation, a third party is being involved where they help in conciliating the dispute or resolving the dispute between the parties. In mediation, here also third party will be involved. Here also third party is being involved. But now there is a minor difference between conciliation and mediation. Here the third party will not get in resolving the disputes. It will let the parties themselves to resolve the dispute. What is the role of the mediator here? Basically to help, to provide some kind of assistance, to help and provide some kind of assistance in resolving the dispute. Otherwise, the mediator will not get actively involved. They will let both the party to talk, and here and there the mediator will assist the parties to resolve the disputes, right? Again, it is non-binding in nature. It depends, whether you want to accept the or you want to resolve the dispute. I mean, in fact, there is no case of acceptance, because the party is not involved in resolving the disputes. It is the party themselves resolve the dispute. What is the role of the mediator? To assist the party in resolving the disputes, right? Negotiation. So in negotiation, no third party is involved. No third party is involved, and the negotiation, it can be done between two parties themselves. So if the two parties have disputes, they can come to a negotiating table and they will try to resolve the disputes. So through these mechanisms, these are the various way of resolving the dispute through the ADR, alternative dispute resolution. These, any of this method can be used. Any of this method can be used in the ADR. So what are the advantage of ADR? Advantage of ADR. So far we have talked about what is ADR and why the need of ADR occurred, and we have seen thirdly the types of ADR, how the ADR takes place, what is the method through which the ADR takes place. And now we are discussing what is the advantage of ADR. So we have already discussed in brief. Let's see in a, you can write it down under proper heading, advantage. So it helps in, deburdening the regular code, deburdening the regular code. So we have already seen there is a huge pendency of cases, and through the ADR, because the cases will go to ADR, so because of that the court will be deburdened. They'll take up more important cases. The petty cases can be taken up by the ADR, right? Secondly, it maintains the confidentiality of the clients or parties. Confidentiality of the parties are fully protected here in comparison to the regular court, when things become much more public. Here the confidentialities of the parties are more protected. Thirdly, it is more viable, efficient, and more economical in terms of getting justice. It is also more speedier form of justice. Why speedier? Because a lot of procedures which are followed in court, it is not been followed in that strict way, and that's the reason the resolution of the disputes takes place in a much more speedier way. it is much more cheaper because the court fees and other necessary expenses are being waived off. So that's the reason it is being a more economic way of getting justice and more speedier way of getting the justice. Specialized experts can be called here. Expert can be, called here. So in the ADR, specific expert, not only, the judges are involved, but even the specialized expert can be called up here, even the social worker can be called up here, and even they can provide insight and inputs into the cases. So because of all these reasons, there are benefits to resolve dispute through the ADR. So now let's see, we have seen, the advantage of ADR. So what India has done in terms of ADR, or what is the status of ADR in India? What is the status of ADR in India? What is the status of ADR in India? So we have a, statutory backing for the ADR, and it has come with the Legal Service Authority Act, Legal Service Authority Act of 1987, under which NALSA, National Legal Service Authority was established in 1995, and then State Legal Service Authority, District Legal Service Authority, they all being established later on. So what is the objective of NALSA? The objective of NALSA, or the Legal Service Authority Act, is basically to provide free legal aid under Article 39A. Under Article 39A of the Indian Constitution, which is there in your directive principle of state policy, that the state must strive to provide free legal aid, particularly to whom? To the disadvantaged section of the society. Disadvantaged section, poorer and weaker section of the society, free legal aid should be provided. So that's the reason we have, in 1987, Legal Service Authority Act was being created, or an act has been passed. After that, under that, NALSA in 1995 came into being, the objective being providing free legal aid under Article 39. So giving effect to Article 39A. NALSA sought to give effect to Article 39A. It made the legalization of Article 39A, enforceability of Article 39A by providing, free legal aid, because it is the rights of every citizens to get free legal aid. Now what is free in this legal aid? Free here is like your court fees will be waived off, lawyers, those who cannot afford for a lawyers or legal practitioner. So even because everybody under Article 22(1), that talks about that every citizens should be, be informed. The ground of arrest must be informed, and secondly, every citizen should have right to get a lawyer's office or legal practitioner's office choice. So suppose if I can't afford to get a lawyer of my choice, or I can't afford to pay the fee of a lawyer, so should I remain legally non-defendant? So India being a democratic country and a welfare state, they aim to provide free legal aid to every citizens. So, I mean, particularly to the poorer. So who can't afford? Poorer and weaker section of the society who can't afford to defend themselves because of the lack of income and all, or lack of monetary resources. Free legal aid is being provided. So that is what the objective of NALSA, to provide free legal aid to the poor and weaker section of the society. So justice, it make justice for all. Justice must be accessible to all. Justice must be accessible to all. So NALSA was created to to monitor and evaluate implementation of legal aid. NALSA was created to monitor and evaluate the implementation of the legal aid, and lay down policies, and also to lay down policies for making legal services available under the Act. So what is the work of NALSA? Why NALSA was created? To monitor and evaluate the implementation of the free aid policy, and also to provide the policy how the free legal aid will be implemented, or how the free legal aid should be provided to the people. They also lay down the policy and monitor and evaluate its implementation. Now, who are the, in prelims the question has also come, so be mindful of all these statements all these information we are talking from these. If you have a really good idea on all these, you have the clarity of idea, you will be able to solve any prelims question and any mains questions on this. Particularly mains will be easily able to solve. Prelims, that of course sometimes depends, if they give you too much of dynamic statement which you are not aware, but it's okay. If you are not able to solve such question, it is absolutely okay. But those which are based on concept, you must be able to solve. So be mindful of all these, the informations we are talking about now. Persons eligible. So who are the person eligible? Person eligible for free legal aid. So who are the persons? See, the question has already asked on this in mains. So please be mindful about this. Women and children. So we have seen that poorer and weaker section of the society. So poor, based on income. Poor and weaker section. Right. So poor based on income. Weaker, those are at disadvantaged position, right? So women and children are in a disadvantaged position. They form the part of the weakest section of the society. So women and children. Scheduled caste and scheduled tribes, they are also the weaker part of the society. With mentally ill and persons with disability, they are also provided free legal aid. Victims of mass disaster, victims of mass disaster like floods, earthquake, or something like railway accidents, man-made or natural disaster, which are of mass disaster. Human trafficking, victim of human trafficking. So victim of human trafficking. Income of the person less than 1 lakh. Now this can be revised. Every state they have their own the income limit to provide the free legal aid. So generally it is less than 1 lakh, but state can have their own income limit. So that will vary. The income limit will vary state to state. Income limit will vary state to state. Generally it is less than 1 lakh. Right, so I hope till here it is clear that who are the persons who are eligible for free legal aid, right? Category of persons who are free for free legal aid. So now let's see the mechanism of ADR. What are the mechanism of ADR through which the alternative dispute resolution can be resorted? So we will talk about here LoAdalat, Gram Nyalay, plea bargaining. So we'll talk about these three here. There are other also like family court. Family court are also a part of alternative dispute resolution. Arbitration tribunal. Tribunals. So various conciliation and mediator centers. They are part of your ADR. So various conciliation and mediator centers, arbitration tribunals, they all are part of your ADR mechanism. So in this we'll basically talk about these three little bit more detail. I'll also make a reference of arbitration tribunal. So let's see one by one. LoAdalat. This is the most popular way of resolving the disputes through ADR, LoAdalat. So it is a forum where the cases which are pending. It is a forum where cases which are pending in the court. Please be mindful of all these words and informations because this could be the part of the statement asked in your prelims, and of course the conceptual clarity is required to good answers in mains. So it's a forum where the cases which are pending in court or are at pre-litigation, which are in a pre-litigation form, all these cases can be taken up to the Adalat. So those cases which are pending in the court. So those cases which are even pending in the court, and those which are at pre-litigation means where the cases has not been taken up to, by the regular court, which has not taken to the court, which are in a pre-litigation stage, pending as well as pre-litigation stage. Both these cases can be taken to this Lok Adalat, where compromised and settlement, compromise and settlement of the case would occur, where compromise or resolution of the case or resolution of the dispute will occur, right? So what are the key things which you have to remember here, which is that pending in the court as well as which are in a pre-litigation stage. Both these cases can be, taken up. So, Lok Adalat is not something very, very new in India. This Lok Adalat, the word itself means people's court, people's court. So this is an ancient practice. It's an ancient practice where earlier, the head of the family used to resolve the disputes, right? Head of the family, like Kula in ancient period, Kula. They used to, or head of the community, they used to resolve the cases. But later on, we had been given, it is in the modern period, we have given a statutory backing. So we have seen in 1987 when Legal Service Authority Act was set up. After that in NALSA, 1995 it came into being, and later on, the Lok Adalats were established on the basis of this National Legal Service Authority Act. The Malimat Committee and 129th report of Law Commission, 129th report of Law Commission in 1988, and the Malimat Committee in 2000, which was constituted to bring reforms in the criminal justice system. The Malimat Committee, which was constituted in 2000 to bring the reforms in the criminal justice system. Both these, the Law Commission report and Malimat Committee, they recommended for the establishment of Lok Adalat. They recommended for the establishment of Lok Adalat or ADR, Alternative Dispute Resolution. So Lok Adalat provides, why Lok Adalat is important, because it provides, just like we have spoken about the ADR, that it provides cheap, speedy, cheap mechanism of justice, cheaper and speedier justice. And here basically the justice takes place through the system of negotiation, conciliation and persuasion. So through these are the mechanism. Persuasion. Through persuasive communication, through negotiation, conciliation and persuasion, the justice takes place, or the resolution of the disputes takes place. It is an informal way through which the settlement of dispute is being done. Informal in the region here, in the manner that, here the parties, they can directly talk to the judge. They can, through of course their counsel, which is not available in the regular court. People cannot directly talk to the judge, in the regular court, but here they can, through their counsel or lawyer, or through their defender, they can communicate to the judges. So it is a informal, where they can directly have some kind of communication, which helps in speedier resolution of the disputes. And of course, it does not follow that elaborate and complex procedure which is followed in regular court. So the justice is also much more speedy. The court fees is also waived, so it is a more cheaper way to get justice. Organization and functioning of LoAdalats. So I hope I am making sense to all of you. You are able to understand. Let's see, organization and functioning. Organization and functioning of LoAdalat. Why I am doing this? Because the question has been asked in your mains, so you must be know a little bit more details. Organization and functioning of LoAdalat. So Supreme Court Committee on Legal Service, High Court Committee on Legal Service, State Supreme Court Committee on Legal Service, High Court Committee on Legal Service, State Legal Service Authority, District Legal Service Authority, from time to time, they can set up LoAdalats. They can set up LoAdalats from time to time, and in the area they think fit. In the area, I mean, where the LoAdalat has to be established, that will be decided by these organization, right? As or the area where they think fit. Retired or serving judicial officer. Retired or serving judicial officers will be the chairman, of the Adalat, LoAdalat. Retired, please be mindful, retired or serving judicial officer, they are generally the chairman. A lawyer, so who are the members? A lawyer, advocate, that is lawyer or advocate, and even a social worker. Social worker, they will be the part of the team who will resolve the dispute. So the chairman is generally an judicial officer, serving judicial officer or a retired judicial officer, and then the team also includes a lawyer or advocate and social worker. What are the matters which takes up? Whether it takes both criminal and civil cases? Yes, the LoAdalats can take both civil as well as civil and criminal cases. But be mindful, the compoundable cases, only compoundable cases. Compoundable cases means those cases which are of minor criminal nature. No, not those cases that involves death punishment or life imprisonment or 7 years of imprisonment. So there are compoundable and non-compoundable cases. Non-compoundable cases, there are more serious criminal matters. So these are more lighter, or you can say the offense are in a nature of less serious. They are less serious criminal cases. So please remember that the cases which are taken up by the LoAdalats, because again such question has been asked in prelims, it is of both civil and criminal cases. But again, in criminal cases you have to remember that it is only the compoundable cases which are of less serious nature. Those cases which involves imprisonment of death, life imprisonment, life imprisonment or death punishment, or 7 years of punishment, those cases which are more sexual assault, murder, such kind of crimes, theft, robbery, theft again, that they can be petty theft, they can be robbery kind of things. So those high profile criminal cases will be cannot be taken up by the local adalats, but it can take the criminal cases, remember that. But in that also only compoundable cases. So what are the generally what cases they take up? Matrimonial disputes, cases of road accidents, minor again, you know, cases of minor road accidents, housing finance kind of things. Such cases, petty theft cases, such cases can be taken up by the Lok Adalats. Consumer grievances, though we have the consumer court, but that related with consumer grievances can be also taken up by them. What is their power? Power of Lok Adalat. So it has the same power as that of a civil court. It has the same power as that of a civil court. Means it can provide the award which can be granted by a civil court. That is what their jurisdiction or limitation you can say. So like they can summon and enforce attendance. Like if they are summoning somebody, the person has to come and, you know, be present. So summoning and enforcing the attendance of any witness, and then also they can get any kind of documents, even public documents. They can send summon to anybody and enforce attendance. Requisition of public documents, even public documents, if they want to resolve the case, such thing has to be produced before the court, public records or so. So their proceedings is deemed to be judicial proceedings. So whatever the proceedings of Lok Adalats, they are deemed to be that of the judicial proceedings only under IPC. Under Indian Penal Code, the proceedings taken up by the Lok Adalats is deemed to be judicial proceedings, though they are informal in nature, but still the proceedings are, they have to follow certain things which is being followed under the judicial proceedings, right? So it will be deemed to be a judicial proceedings only, and they'll have a power of a civil court. Whether their award is binding or non-binding, the award or the decree issued by the Lok Adalat, whether it is binding or non-binding, it is binding. So again, this piece of information also remember, because they had asked question on this binding, and whether appeal can be done. No appeal can be done, right? So it is final, the award given by the Lok Adalat, it is binding, and generally no appeal can be taken up. Exceptions are always there, but generally no appeal can be taken against it. It is final and binding. In 2002, there was amendment in Legal Service Authority Act which called for establishment of permanent Lok Adalat. So just now we have seen that, you know, the State Legal Service Authority or the Supreme Court Legal Committee, they can call for the establishment of Lok Adalat from time to time and in the area which they deem fit. But then there was an amendment in 2002 in the Legal Service Authority Act of 1987, which called for permanent Lok Adalat. So now by this time they realized the utility of the Lok Adalat and they wanted to make it a permanent features. So what are the features? Almost the same features we have spoken. Features of permanent Lok Adalat. Features of permanent Lok Adalat. Chairman, who will be the chairman? Either serving or retired district judge or additional district judge. District judge or additional district judge, they will be the chairman. It can take up the cases, which is of monetary value or pecuniary value of not more than 10 lakh. Not more than 10 lakhs. So those cases involved less than 10 lakhs or 10 lakhs, those cases can be taken up. Those cases involving more than 10 lakhs, that cannot be taken up. It can take up again both, the civil and criminal cases, but criminal only compoundable, not non-compoundable. Non-compoundable cases cannot be taken up. Award is final and binding. Award is final and binding. Right, so we have already done in the Lok Adalat. In the permanent Lok Adalat, the chairman, it is mentioned that it is either serving or retired district judge. It can take up the cases of monetary value of equivalent to 10 lakh or less than 10 lakh, but not more than 10 lakh. Again, these piece of information can be useful, can be asked in the prelims. It can take up the both civil and criminal cases, but criminal it is only compoundable cases, non-compoundable it can't. Yeah, so we are done with the Lok Adalats. Let's quickly see Gram Nyayalayas, because we have spoken in the beginning that we'll look into Lok Adalats and Gram Nyayalayas as well as Arbitration Council will look into. Gram Nyayalayas. So the Gram Nyayalayas Act 2008 called for the establishment of Gram Nyayalayas. This is another mechanism of ADR. It is like a mobile court. So taking justice more closer to the people. It is providing justice at the doorstep. It is providing justice at the doorstep. Justice at the doorsteps. So you know that in rural areas, people are even more lack of awareness about the legal proceedings or all, right? The legality of the cases and the legal issues, they are even more, there is lack of awareness in the rural areas. So that's the reason the Gram Nyayalayas has come into being, so that, people should not come, because many a time people do not come to the dispute resolution mechanism or the court. So the court goes to the people, right? Court goes to the people. So this mobile court, it is a mobile court, and the idea is to provide justice more accessible to the people, taking it to the doorstep of the people, particularly in the rural areas, because there is lack of awareness of the legal issues. So it can also take up the cases of criminal, civil. So same like Lok Adalat, it can take up those cases. Again, the power is of that of a civil court. Power is that of a civil court. and it will be headed by judicial officer of first class judicial magistrate or judicial officer of first class. It will be headed by. Appeal can be taken up here. Here one more thing you have to, as in LoAdalat there is no system of appeal, generally no system of appeal. Here the appeal can be taken up, like the appeal can, in the civil cases it can go to the district court, in the criminal cases it will, in the criminal cases it will go to the session court. In the civil cases it will go to the district courts. The appeal can be go, and within 6 months the final appeal, you know, whatever, it has to be resolved in the district court or the session court. This is what the features of a Gram Nyaya is. So now let's see the questions. So we have done with this, right? We have done with the Gram Nyaya, we have done with the LoAdalats, and so now let's see the prelims and mains question. What in the prelims and mains question it has been asked. So 2020, one question has been asked, in which that's in India, the question is, in India, the free legal aid or, you know, the legal service authority provides aid to which type of citizens? So A is annual income less than 1 lakh. Transgender. Second statement is transgender annual income less than 2 lakhs. Transgender annual income less than 2 lakhs. OBC, other backward classes, income less than 3 lakhs. Number 4 statement was it is to all the senior citizens. So that is what the question was about, that legal service authority provides the free legal aid to which category of people. So we have already seen, right, that income is one of the criteria to provide the legal service aid, free legal service aid. So those who belongs to low income group basically. So now this type of question, again, that depends on if you have the knowledge of the current affairs, because all these informations may not be provided in the conventional source and conventional material. So the first statement is correct, the annual income is less than 1 lakh. For the transgender also, whether it is of 2 lakh. So first statement is correct. Transgender incomes less than 2 lakhs. This is also, it is mentioned 2 lakhs, it is correct. For the OBC, because, you know, OBC has not been defined under the weaker section of the society as per the Legal Service Act. The OBC has not been defined. We have seen SC, ST, women, and also there was one income criteria. So for income criteria, yes, less than 1 lakh, correct. Transgender, particularly there is one section of society which are at disadvantage section. So even they are being included, and those income less than 2 lakhs. Transgender income less than 2 lakhs, even they are included. OBC has not been defined under or not been included. So it's not about their any people who are poor, less than 1 lakh income, and it depends upon the state. Some state they may give 3 lakhs and all, but generally it is 1 lakh rupees. So OBC has not been included. All the senior citizens, whether it is available to all the senior citizens, again it is the senior citizens are not been included. That depends upon state to state. The state can give, but not generally at the central level. Such act has not been there. So senior citizens, of course, those where incomes are under the specific limit, they can get. Otherwise, those who are quite affluential senior citizen, affluent senior citizen, they don't require free legal aid, right? So that's not been given. So this statement is incorrect, this statement is incorrect. So the option was, A, 1 and 2 only, B, 3 and 4 only, 3 and 4 only, C, 2 and 3 only, 2 and 3 only, 2 and 3 only, and D, 1 and 4 only. So this was the option. So we already have seen that first statement and second statement are correct, third and fourth are incorrect. So the answer is A. So this type of question, it is bit not very easy to handle, particularly if you don't know or you are not very clear about the annual income, you may find it difficult. But if you know, you can easily do it. This fourth statement can be easily eliminated because it is not available to all the senior citizens. We have already seen in the category of the people, right, who are the weaker section, women, children, SC, ST, person with disability, they come under the weaker section of the society. So, and the poorer, the income limit is being mentioned. So in all the criteria, all the senior citizens do not fall. So this statement is incorrect. So anyway, we can, even if we know this, the fourth one, we can eliminate this and we can eliminate this, right? B and D we can easily eliminate. Even if you don't know the entire information, many a time through the technique of elimination, you can still solve the prelims question, even this type of dynamic question. So now what are the options left? 1 and 2 and 2 and 3 only, right? So here again, if you know at least one option that one is correct, you can mark it, right? Because in here there is no one, it is only 2 and 3. So since there is no one, so this statement is also wrong. So what goes, even if you don't know this, the transgender one, whether it is there or not, still you can mark it. If you don't know, if you know that option 4, you know that it is incorrect because it is not available to all the senior citizens, those who are affluent, who can easily afford, for them the free legal aid is not available. And by the logic also little bit you will be able to solve it, right? And even if you don't know this number 3, whether it is correct or not, but if you know number 1 is correct, if you know number 1 is correct, you can mark it A, because by 4, this 2 option gone, D and B is gone, because both in that fourth option is there, which we know that it is not correct. And if you know at least one statement, that is number one, if you know that it is correct, you will be able to solve even this type of question by the technique of elimination. The next question. With the reference to legal authority, which of the following statement is correct? Or sorry, with the reference to LoAdalat. With the reference to LoAdalat. With the reference to LoAdalat, which of the following statement is correct? These are correct. So number one, which of the following statement is correct? Is correct. Is correct. So it will come under A, B, C, D mode. A, B, C, D. So A is LoAdalat has jurisdiction to settle matter. LoAdalat jurisdiction to settle the matter at pre-litigative stage. At pre-litigative stage, and not pending before any court, and not pending before any court. So in 2010 this question was being asked. Number B, it deals with civil and not criminal cases. Deals with civil and not criminal cases. Criminal cases. Number C, C was every LoAdalat either served by serving or retired officer only. Serving or retired officer only. And not any other person. And not any other person. Number D, none of the above. Number D is none of the above. None of the above. So please look at the question. It is with reference to the LoAdalat, which of the following statement is correct? So LoAdalat jurisdiction only pre-litigative stage and not pending before the court. So this statement is wrong because we have already discussed that pre-litigative stage as well as pending in the court, both the those cases can be taken up to the LoAdalat, isn't it? Even the pending cases. So we have that's the reason I was telling you, be mindful and please pay attention, concentrate on those important points, because that could be asked in the prelims question. So this is what it has been asked, and these questions are very traditional, conventional, easy to answer. If you have studied really well, you can easily answer these questions. Part of a conventional, I will put it under the conventional topic. So this statement is wrong. Deals with civil and not criminal cases. So this statement is also wrong because I already discussed that it deals with both civil as well as criminal cases. Though criminal cases of serious offences, they are not taken up, but still criminal cases are taken up. either served by serving or retired judge only. So again, the word only, wherever the word only, absolute words come, we have to scrutinize it really very well, because many a time such statements are incorrect when the word absolute word, must only are being there in the statement. And we know that we have already discussed that the retired or serving district judge, they are the chairman, but there are other members as well, like the advocate or lawyer, and even a social worker can be the part of that team, right? So not any other person, because they are not talking about chairman here, it is talking about who are the members basically. So it is not a single member body, it can be multi-member body where even advocate and social worker, even some expertise can be called off, right? So the answer will be, since all the statement is wrong, so answer is D, none of the above. All the statements are wrong, right? So I hope you are getting, how to solve the question. If your concepts are really good, really well, and in the previous question I told you how through the technique of elimination you can solve many dynamic question as well. If you know out of the 4 statement, even if you know one statement or 2 statement, you can still solve those questions. And this kind of question, if your concepts are very clear, you can easily solve this question. I'll put it under the easy category. If you have really learned the concept, you will be able to solve it. Now let's see in mains. In mains particularly, they have been asking the question very, very frequently in 2023 and 2024. They had asked the question. So back to back, they had asked question on this. In 2023, who are entitled? Who are mains questions? Mains. Who are entitled? Who are entitled to receive free legal aid? Who are entitled to receive free legal aid? Assess the role of NALSA. Assess the role of NALSA in rendering free legal aid. In rendering free legal aid. Free legal aid. So this question in 2023. So look at the question here. Who are entitled to receive? So this is quite factual question. The first part of the question, who are entitled for free legal aid? So look at the question. Sometimes the knowledge of prelims also helps in your mains, isn't it? Because for prelims you would be studying who are the people who are entitled for free legal aid. And then the second part is little bit more related with the analysis part, where you will have to put some examples, some data to support your answer. So first part of the question is more conventional, traditional, conceptual. The second part of the question is more dynamic in nature. So the first part, who are entitled? You talk about, the NALS. First you can talk about the NALSA, why it was established. It was established to provide free legal aid and basically to monitor and evaluate the implementations of the the policies which are being laid down by the Legal Service Authority Act of 1887. And talk on that basis, the NALSA was being created in 1995. First you talk about the Legal Civil Service Authority Act 1987 to provide free legal aid to the people of poorer and weaker section of the society. Then also you talk about 1995, it was established to monitor and evaluate that how far the policy is being implemented, and also to lay down the policy for providing the free legal aid, to provide the policy and look at it to the implementation for free legal aid. That is what the work of the NALSA. And of course, to create awareness regarding the free legal aid. That is also to create awareness. So you talk about that in your introduction part. Introduction part, you can talk about NALSA and all. And then in the body part, you talk about who are the people. So body part it will be two part. Number one, that who are the people who are entitled for the legal aid, and then also you also talk about the assessment of the role of NALSA. To what extent it has fulfilled its purpose, right? So who are the people who are entitled? So we have already talked about that who are the people. So who are the people who are entitled? In this you write about women and children, scheduled caste, ST and SC. Who else? Mentally ill people and person with disability. Mentally ill people and person with disability. Then victims of mass disaster, victims of human trafficking, and those whose income is less than whatever specified amount, less than the specified amount. Even if you don't know the amount, you can write the specified amount mentioned in the act. So these are the category of people who are entitled, who are weaker and poorer section of society. And of course you mentioned about Article 39A, that's very, very important, that under Article 39A they are supposed to get the free legal aid. You can mention under Article 21 and 22(1) also you can mention. 21 is right to life and personal liberty, and the Supreme Court has interpreted in a very, very diverse manner, in a very elaborated manner, and one of the part, or basically the right to life and liberty also means right to have a good quality life. So under that the Supreme Court has already included provision for free legal aid. Provision of free legal aid has been interpreted under Article 21 of the Indian Constitution by the Supreme Court, and then you can little bit write about Article 22, where every person who are arrested, they have to be provided with the information why are being arrested, the ground of their arrest, and secondly also they should be given legal practitioner of their choice to defend their cases, right? So under all these provisions, of the Indian Constitution, that is what the NALSA work, that is why the NALSA was established. Then the second part, assessment of the role. Assessment of the role. How NALSA has basically worked. So in this you write both the work or achievement, and also their lacuna. Mention about their work and their achievements. and also their lacuna or the loopholes or the area where they could not much achieve. So with where you have to find little bit of more data also. So what is their role basically? What is their role? What is their work or role? Making legal services available to the people. Available to the people. So expanding the reach of justice, isn't it? The reach of justice, expanding the reach of justice and also making the justice more accessible and affordable. I mean, it's not affordable because they are not charging any money, so accessible. Making it more inclusive, making it more, inclusive. The reach of justice should be, it should reach to every people. So in that way, it is expanding the accessibility and making the justice more inclusive through the system of ADR, alternative dispute, ADR, alternative dispute mechanism, which results in de-burdening of the court, de-burdening of the court, you can write about that. Also, it helps in awareness campaign, creating more awareness campaign regarding the legal issues. So these are basically the roles and all. Then you talk about the challenges. Then you talk about the talk about the challenges. So under challenges, you can talk about that resource constraint. So this resource constraint is with almost all the institutions in our country. Those resources are very limited, and it is said that as per India Justice Report, so if you quote such kind of report, 2019 this report has come, India Justice Report. It is said that per capita expenses for legal aid, is 0.5 rupees, just 1.05 rupees per capita expenditure on providing legal aid to the people of India per capita is just rupees 1.5, which is much below the global standard, Then you can talk about that there is a shortage of staff, well qualified legal practitioners. Shortage of well qualified legal practitioners. So that is also one of the lacuna or challenges. So it is said that as per the same report, 629 was the vacancies or the post, 629 posts to be filled for district legal service authority. For the district legal service authority, 629 posts are there. Out of that, 573 posts were being filled. So of course, since they were not working with full capacity, there is a shortage of enough well qualified legal practitioners. So this is one challenge and one lacuna. Then lack of legal awareness. legal awareness. People are not aware about that. They are not aware about that. They are provided with such kind of facilities. Many people are not aware that we are provided with free legal aid. So that is also one of the lacuna and all. So having talked about their achievement, the role, and also talked about the challenges and the issues before the NALSA, then you conclude it in an appropriate manner. Write the conclusion. So in the conclusion, what will you write? So in the conclusion, you write out about, why NALSA very, very important. With the achievement of NALSA, the role of NALSA is very, very important in providing free legal aid to the people, in creating awareness about the legal issues. Its role is very, very important and very, very essential. But at the same time, it has to collaborate with the government, collaboration. Collaboration with the government, civil society. It must collaborate with the government and the civil society so that the free legal aid or the objective of NALSA is fulfilled, and the free legal aid becomes more accessible, and the justice become more inclusive. So in this way, you can positively conclude on NALSA. And what it has to be done, it has to be a little bit, you just mentioned about more resources and more well qualified staff need to be made available under the NALSA, so that the objective of NALSA can be fulfilled in a productive manner. And this is how you conclude. Right, so we have discussed 2023 mains questions. So back to back, as I said, this topic why I took up, because for quite some time UPSC has been asking very often on alternative dispute resolution mechanism. So 2024, let's see very quickly the question. Explain and distinguish. Explain and distinguish. So they are asking explain and distinguish between LoAdalat and arbitration tribunal. Arbitration tribunal. Arbitration tribunal. Whether they can take up civil and criminal case as well. Civil and criminal case as well. So 2024 10 marks question. 10 marks means 150 words you have to write. Look at the question. Explain and distinguish between LoAdalat and arbitration tribunal, whether they can take up civil and criminal cases as well. So again, I talked about some of the points which we feel that it is only important for prelims. It is not like that. Even in mains questions, they are asking such type of the questions where the knowledge of your prelims or the factual knowledge is very, very important. Because somebody who are not very clear about whether they take up only civil cases or criminal cases. And also they are asking it to distinguish. Yeah, so you can LoAdalat and arbitration tribunal. So before that, a little bit talk about in the introduction itself, talk about what is LoAdalat and arbitration tribunal. So you know about the LoAdalats. We have already spoken about the LoAdalat. What is arbitration tribunal? So it is basically a specific tribunal which take up the cases of commercial in nature, mostly commercial in nature, where there is an agreement between two parties. So those cases which are contractual in nature, basically. Arbitration is basically what the word itself is, to basically to mediate or to kind of provide a judgment. I mean, for that matter, the judge acts as an arbitrator only. So here the specific cases will go which are where contractual agreement is involved. In comparison to the LoAdalat cases, where any general cases, both civil and criminal cases can go there, and which are general in nature, right? Which is general in nature, no specific or no such. I mean, it is not like they had mentioned that only contractual agreement. Such cases involving the breach of contractual agreement will only go. But here in arbitration tribunal, so they have under. So these tribunals are mentioned under arbitration and conciliation act 1996. So those arbitration tribunals are those tribunal which are created under Arbitration and Conciliation Act 1996. And here only those cases generally involved of commercial agreements which are contractual in nature, such cases are being taken up. So now let's see the differences. So what are the differences here? So here parties they will voluntarily, if they want to go, they will go voluntarily to the LoAdalat. And here both pending as well as pre-litigating cases can be taken up. Pending cases in the court as well as the pre-litigating cases can be taken up. We have already spoke about. Here some kind of where parties are in some kind of pre-existing agreement. So as I mentioned that arbitration tribunal, not all the cases will go, only those cases where some contractual agreements are involved, right? Pre-existing contractual agreements are involved and there is any disputes related with the agreement, then such cases can be taken up where? In the arbitration tribunal. Whereas all, the general cases can be taken up by the LoAdalat. What is the second point of differences? Here they can handle both civil and criminal cases. Civil and criminal cases. But criminal only compoundable, remember that. Minor offences can take in both civil and criminal, because the question was, we have already seen in the question that explain and distinguish between LoAdalat and arbitration tribunal, whether they can take up civil and criminal cases as well. So that this is what the point of difference. This is what the point of difference. Here the civil and criminal cases both can be taken up, whereas here only civil cases. Only civil cases can be taken up. So that is what the point of difference. Another point of difference, which are mostly commercial in nature, disputes which are commercial in nature. Commercial in nature, based on certain contract. Here the findings. Here the judgment is final and binding. Here the judgment, whatever the judgment is given, that is final and binding. Generally, no appeal can be taken up. No appeal. Here the judgment is binding. The judgment is binding, but appeal can be, if you are not satisfied with the judgment, appeal can be taken up. Appeal can be taken up to the higher authority. Here the nature of proceedings are more informal. Here the nature of proceedings are more informal in nature, where here the nature of proceedings are more formal in nature. So this is what the point of difference you have to write. It's a 10 marks question. So 150 words. These are the points of differences. If you mention that, parties, those cases which are pending before the court, as well as in the pre-litigating cases, that can be taken up by the LoAdalat. Whereas here some kind of pre-existing agreement, or the nature which is contractual agreement, disputes related to contractual agreement, such cases be taken up by the arbitration tribunal. Secondly, in the LoAdalat, civil and criminal, both the cases will be taken up. Here only civil cases or those which are commercial in nature will be taken up by the arbitration tribunal. Thirdly, under the LoAdalat, we have seen the judgments are final and it is binding in nature, no appeal. Whereas here it is binding, but appeal can be taken up. Here the proceedings are more informal in nature, whereas here the proceedings are more formal in nature. So this is how you can write. It's 150 words. I think if you know these points, you can easily write, and you can wind it up. So with this, I tried to cover in a very comprehensive manner alternative dispute resolution. What is ADR? We have seen, the types of ADR, and then we have seen why ADR is required, what are the need and what are the advantage of ADR. We have also seen under that, what is the status in India about the ADR. So under that we have talked about NALSA, isn't it? We have talked about the Legal Service Authority, and then we have talked about NALSA, what is the role and what is the mandate of NALSA. And after that we have seen the various mechanism of ADR, that is LoAdalat, Gram Nyayalayas, arbitration tribunals and all. There are other ADR also, like family courts, plea bargaining. These all are part of your ADR. And then we have discussed prelims, some 2 questions on prelims we have discussed, and then we have also discussed 2 questions of mains, back to back they had asked in 2023, they asked 2024, they had asked, and the earlier also they had asked. So that's the reason, I had taken up this topic because it's getting more and more importance as far as the UPSC is concerned. So I hope, I try to make the things quite clear. So if you have any doubt. So I couldn't see any, message there on doubt. But anybody, after this also, you can follow the entire topic. And if you have any doubt, you can put it in the chat box and we'll try to resolve it. Thank you. Thank you so much. May this session be very useful to you. All the very best.